Good day. Today is the 10th of July 2020, and we are still in lockdown in South Africa. It's Rion Peters de Villiers and Associates. I haven't posted a video for quite some time because I don't think there was anything relevant to say in terms of the lockdown procedures and all the other matters that we discussed. What I want to discuss briefly today is what has become a very harsh reality for many employers and employees in South Africa over the last few months and weeks, and that is retrenchments. Now, we have spoken about retrenchments, and we have spoken about the possibility of retrenchments and the options short of retrenchments, like working short time, for instance. But we've not really discussed in detail as far as how retrenchments actually work. It has unfortunately become a very, very harsh reality for many, and I think that possibly 50, maybe even more percent of the work that I do at the moment is made up of retrenchments. Now, I'm not going to do a in detail video on retrenchments. Obviously, you need to be guided by whoever assists you with that. But what I do want to mention is the following. Number one, we need to realize that it is a formal process. Retrenchments falls under Section 189 of the Labour Relations Act, and it is a very well-defined piece of legislation detailing exactly what should happen when there are dismissals for operational requirements. What I want to mention today is, one, please do not endeavor to do this on your own. Ensure that you have someone, an expert, to assist you with this process, because it may eventually be more costly if you try and do it yourself. Section 189, as I said, is very well defined, and the two major issues that one would look at if it ends up the CCMA, as with many other employment law matters, is number one, was there merit in the dismissals? Now, in most cases, there would possibly be merit due to the dire financial situation of many companies in this COVID-19 pandemic. But there must be merit in the operational requirements dismissals. The other important thing is the other arm that the CCMA would look at would be the procedural aspect of the process, which is also very important. And that is also well defined in Section 189 of the Labour Relations Act. So very important, number one, to make sure that you are guided by an expert. Number two, the two arms at the CCMA that would be applicable if it ended up at the CCMA would be merit and procedure, to ensure that you comply with both. Not to go into detail, but the retrenchment process itself is started. Then there are consultations. The law says that there must be meaningful consultation. If an employee, for instance, wants to make certain suggestions, they may suggest to work at a lower salary, less hours, but an employer must, in these consultations, in these meaningful consultations, consider what the employees are giving as feedback. It doesn't mean that the employer must necessarily accept all the feedback given, but they must look at it and evaluate the feedback that they get from the employees. Then it can culminate in either an employer ending off a retrenchment process if consensus can't be reached on any of the matters that are defined in the legislation, or otherwise, which is the better option, it could culminate in a settlement agreement that is drafted between the employer and the employee. This settlement agreement will detail the severance pay. It will detail any other matters that are agreed upon in these negotiations or consultations. Why I say it is better, because there would obviously be a clause in the settlement agreement to state that this is the final settlement agreement between the parties, and therefore there won't be lengthy CCMA cases afterwards. And this is just a very brief overview of a Section 189 retrenchment procedure. Some important facts that I wanted to mention. We, of course, at Peters de Villiers and Associates can also assist you with advice and guiding you through the process. But if you are further afield and not in the area that we work in, please make sure that you consult an expert, because it may result in you ending up at the CCMA with many cases being referred due to the process not being followed the correct way. It's very unfortunate that we have this situation in South Africa, but it is also a situation that is worldwide at the moment. I also believe that if one enter into these consultations, it is called a no-fault dismissal, and therefore I do believe that it must be done with compassion. These consultations should be done with compassion, because it's not the employer's fault, and it's also not the employee's fault that they ended up in a Section 189 process. If anyone needs any guidance, you can contact us via our Facebook page. You can contact us via our WhatsApp group if you are on the WhatsApp group, or otherwise you can phone our office 028 313 0602. All of the best in the cold weather, and stay safe, stay warm over this cold weekend, and let's hope and pray that the situation in South Africa gets better sooner rather than later. Many thanks.